All right, everyone, let's jump right in. If you're prepping for your CA Foundation exams, you know the Indian Contract Act is a beast. Well, today, we're going to demystify one of its most fundamental concepts, consideration. Let's get this nailed down.
So, let's start with the big question. Just think about it for a second. Why isn't every single promise you make a legally binding contract? You make promises all the time, right? So what's the secret sauce that turns a simple promise into something you can actually enforce in a court of law? And there it is, that one word, consideration. This is the bright line, the absolute key that separates a casual promise from a rock-solid, valid contract. It's what gives a promise its legal teeth.
Here's our game plan for this explainer. First, we'll break down what consideration even means. Then, we'll get into the essential rules you have to know. After that, we'll tackle the tricky stranger to a contract rule, and we'll wrap up with the most important part for your exams, all the juicy exceptions.
Okay, Section 1. What in the world is consideration? Honestly, the simplest way to think about it is right here. It's the price of a promise. In any contract, each person has to give something to get something. That's the core idea.
Now, you're going to hear this fancy Latin phrase thrown around, quid pro quo. Don't let it scare you. All it means is something in return. It just reinforces that a contract is a two-way street. It's an exchange. I give you something, you give me something back. That something is the consideration.
All right, let's look at the official legal definition for a moment, straight from Section 2D. Now, I know that sounds like a bit of a mouthful, but a couple of phrases here are pure gold for your exams. See that part that says, at the desire of the promisor? Super important. The request has to come from them. And notice it says the promisee or any other person. That's a huge point we're going to come back to. So, what can this something actually be? Because, it's not always about cold, hard cash. It could be an actual act, like selling some goods. It could be an abstinence. That's just a fancy word for promising not to do something you have a right to do, like sue someone. Or it could just be another promise for something down the line. All of these count.
Okay, let's move into our next section. You see, it's not enough to just have something in return. For that something to be legally valid, it's got to follow some very specific rules. Think of them as the official rules of engagement for making a contract.
Okay, everyone, screenshot this in your brain. These are the 5 golden rules you absolutely have to know. 1, it has to be what the promisor asks for. 2, it can come from the person getting the promise or even a total third party. 3, it can be for something already done, happening now, or happening in the future. 4, the value doesn't have to be fair. And 5, it has to be real, not some impossible fantasy.
This quote really hammers home that first rule. It's based on a landmark case where a guy built some shops because the town collector asked him to, not because the shopkeepers asked. Later, when a shopkeeper promised to pay him a commission, the court said, nope, not a valid contract. Why? Because the work wasn't done at the promisor's request.
And this brings us to the adequacy rule, which always seems to surprise people. Imagine selling a house worth 60 lakh rupees for just 10 lakh. Sounds like a terrible deal, right? But is it a valid contract? You bet it is. The law is not there to save you from a bad bargain. As long as there is some consideration and you agree to it, the deal stands.
This one's pretty straightforward, but you'd be surprised. The consideration has to be real, not something, imaginary. A promise to find treasure using magic? Or to make it rain gold coins? Yeah, that has zero value in the eyes of the law, because it's impossible. It can't be valid consideration.
Building on those rules, let's get to Section 3. Now we're going to tackle what I call the outsider problem. The official legal term is the doctrine of privity of contract, and really it all boils down to one simple question. Who gets to sue if something goes wrong?
So here's the bottom line, the general rule you have to start with. If you are not a party to the contract, you can't sue on it. If you're a stranger to the contract, meaning you didn't make the agreement, you generally have no legal right to enforce it.
Okay, pay close attention because this is a distinction that trips up so many students on the exam. In India, a stranger to consideration is totally fine. Remember Section 2D? The consideration can come from any other person. But a stranger to the contract, that's generally a no-go. They can't sue. They are 2 totally different ideas, and you have to keep them straight in your head.
And that brings us to our final and, I think, most important section. Look, understanding the rules is great, but knowing the exceptions is what's going to set you apart. This is where we learn when all those solid principles we just discussed can actually be broken.
So, how do we break that no strangers allowed rule? Well, the law carves out some very specific exceptions. A few are about protecting a beneficiary, like in a trust, a family settlement, or certain marriage contracts. Others have to do with the contract itself, like when rights are formally assigned to someone else.
And if you need a case to make this stick, look no further than Chinaya versus Ramaya. It's a classic. Here's the story. An old lady gave property to her daughter. The deal was that the daughter had to pay an annuity to the lady's brother, her maternal uncle. The uncle was a stranger to this deal, right? But the court said he could sue because the entire contract was set up for his benefit.
Okay, get ready for the biggest plot twist. We started this whole explainer by saying consideration is the key. The general rule is simple: no consideration, no contract. But what if I told you that even that fundamental rule has some massive exceptions?
And here they are, the 5 big exceptions under Section 25. A contract can actually be valid with 0 consideration in these cases. If it's a written, registered promise between close relatives out of love, if it's a promise to pay someone back for something they already did for you voluntarily, a written promise to pay a debt that's legally expired, creating an agency, and of course, a completed gift.
Let's make that really practical. Say you find someone's lost wallet, and you're a good person, so you return it. That was a past, voluntary act. The owner is so grateful they say, "Thank you so much. I promise to give you 10,000 rupees." That promise is now a legally binding contract, even though you didn't do anything new in return for it.
So let's boil this all down. Here are your key takeaways. General rule: a stranger to a contract cannot sue. The big exception: situations like a trust or family settlement. General rule number 2: every contract needs consideration. The big exception: things like promises made out of natural love and affection. If you can remember this table, you're in great shape.
And I'll leave you with a question to chew on as you study. Looking at all these exceptions we just covered, from who can sue to when you don't even need consideration, which of these do you think is prime material for a tricky case study question on your exam? Seriously, think about it. It'll help you focus.
Remember, the bottom line is this: you've got to know the rules to pass, but you need to master the exceptions to really score high. I hope this has helped clear up the whole concept of consideration for you. Good luck with all your prep.